behalf of Lanny Brewer and myself, we do have some preliminary remarks that we would like to make. Mr. Smith is committed to providing information to this committee about the work of the Special Counsel's office, while following all laws and rules restricting a former prosecutor's ability to disclose certain information. To that end, we appreciate the committee's assistance in working with the Department of Justice to provide Mr. Smith with authorization and clarification on the parameters around Mr. Smith's testimony today. Of course, some restrictions remain on Mr. Smith's testimony, two of which I would like to highlight before we begin. First, as the committee is aware, in its letter of December 11th, 2025, the Justice Department admonished Mr. Smith that he is not authorized to divulge information that is prohibited by law or courts, including that which is subject to Federal Rule of Criminal Procedure 6E. It is our understanding from communications with the committee and the Justice Department that DOJ is interpreting a matter under Rule 6E to be limited to the inner workings of the grand jury. On a call with committee staff and with the Department of Justice on December 11th to discuss the scope and application of grand jury secrecy requirements, Assistant Attorney General Patrick Davis agreed with Mr. Castor's statement that based on DOJ's authorization letter and its interpretation of Rule 6E, it would be virtually impossible for DOJ to prosecute Mr. Smith for violating grand jury secrecy restrictions. Second, according to the Justice Department, discussion of Volume 2 of the Special Counsel's reports and any information or conclusions in Volume 2 or in drafts thereof is specifically prohibited by Judge Cannon's January 21st, 2025 order. This morning, just over an hour ago, the Department of Justice sent us an email affirming its view that Judge Cannon's order applies to Mr. Smith and that it precludes him from disclosing any non-public information that may be contained in Volume 2, including, but not limited to, interview transcripts, search warrant materials, business records, toll records, video footage, records obtained by grand jury subpoenas, attorney-client communications, and potential Rule 404B evidence. This restriction significantly limits Mr. Smith's ability to discuss the classified documents case. Nevertheless, Mr. Smith is committed to doing his best to answering questions consistent with the department's guidance. And I ask that that email from the Department of Justice that was sent earlier this morning be made part of the record.
That'll be Exhibit 5.
Thank you. I also want to clarify that the email from the Department of Justice says that Mr. Smith can disclose information in answering questions where that information is in the public record and has been made publicly available through authorized means. And I want to specifically cite that language because yesterday the Department of Justice disclosed to Senator Grassley some emails related to the execution of the search warrant at Mar-a-Lago. I anticipate that those emails may be used during today's deposition and that Mr. Smith may be asked questions about that search warrant and the probable cause supporting the search warrant that was signed by a judge in the Southern District of Florida. And I just want to confirm our understanding that because those emails were released by the Department of Justice to Chairman Grassley, everyone here has a mutual understanding that those emails were made publicly available through authorized means.
And we would concur with that. In our discussion with the Justice Department, and it was in the context of the member toll records subpoenas, they indicated that documents that are in the public realm are fair game for discussion and don't apply to the 6E prohibition, the disclosure of 6E material. And we would further acknowledge that if Senator Grassley posted these materials on his official website, that is an authorized release. I mean, these are materials that were produced to the House and the Senate, And if Senator Grassley posted them publicly, they are certainly part of the public record.
Thank you, Mr. Castor. We are in agreement.
Mr. Castor, can I just note one thing for the record, that counsel for the minority have not been involved in any of the discussions that Mr. Kosky just discussed between the Judiciary Committee and Department of Justice. I just want to make that clear for the record.
All right, noted.
Thank you. My understanding is that if, for whatever reason, the questions today move into an area that we believe Mr. Smith cannot answer because of some legal restriction, we have reached an agreement with the committee staff that we will raise our concern in the moment to see if we can navigate around the restrictions. And if we are unable, we will move on to another topic and then revisit that issue during a break or at the end of the day. Yes.
Just to augment what my partner said, we had proposed to the Department of Justice that it have a lawyer here present today, so that if any issue came up, we could immediately resolve it, because Mr. Smith is committed to answering every question he can lawfully. The Department of Justice chose not to have a lawyer here today.
Thank you. Finally, I feel compelled to make an observation about the risks of participating in this deposition. The most powerful person in the world has said that Mr. Smith should be in jail because of his work as special counsel. Not because Jack did anything wrong, but because he had the audacity to follow the facts and the law and apply them to that powerful person. And through its actions, this Justice Department has demonstrated its eagerness to follow President Trump's orders, despite the facts and the law. Yesterday, the President's Chief of Staff is reported to have confirmed in interviews that the President is indeed pursuing criminal prosecutions against his perceived adversaries as part of a retribution campaign. In the face of those threats, Mr. Smith appears today undaunted, comforted by the knowledge that not only did he do nothing wrong, he conducted his work as special counsel with integrity, impartiality, and an uncompromising commitment to the rule of law. If the committee will allow, Mr. Smith has some remarks that he would like to share.
Okay, but before that, I would just note from Exhibit 4, the December 11th Justice Department letter, they specifically say, the last paragraph on page 2, as to your question about the department's recent disclosure to Congress of certain internal communications considering whether to authorize toll record subpoenas, which Congress publicly released on November 25th, 2025, you are correct that the department does not believe that the specific materials it produced to Congress are covered by 6E for the reasons described above.
Thank you, Mr. Castor. That's helpful. We are in agreement on that. My concern is that that doesn't address Judge Cannon's order, which the department has said Mr. Smith is still bound by because the toll record subpoenas were not part of the classified documents case. And so Judge Cannon's order is a separate legal restriction that exists independent of Rule 6E.
Okay, and I would just note on our call with the Justice Department, their position was, of course he can talk about it if it's in the public realm. And that admonition from the department was not limited to, the toll records question or something in, Judge Cannon.
Thank you.
Mr. Smith, you had some remarks as well?
Yes, thank you. Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election, and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
Can you get a copy? Do you have a copy?
I'm sure.
We can get you a copy, yeah.
You just made some pretty definitive statements about, your belief that President Trump was guilty of these charges. Is that correct?
Yes, I believe we had proof beyond a reasonable doubt in both cases.
And doesn't the Justice Manual prohibit prosecutors from asserting that a defendant is guilty of something before a jury makes a determination?
When a case is pending, yes.
Okay, and so you think you're free from that, from the Justice Manual rules, once a case is dismissed?
No, I think that it's important to state clearly the amount of evidence we had and the basis for why we proceeded. Why we proceeded as we did is because we had a strong case, as I set forth in the final report.
But your final report makes what seems to be conclusive determinations of President Trump's guilt, as opposed to laying out simply the facts and the evidence that you have. I mean, you draw those conclusions that, in your view, he's guilty. Is that not the case?
Well, to be clear, the cases were never tried. We were never put to our burden before a jury, so we didn't conclusively prove it. The reason the report was written the way it was written, and the reason I said what I just said, is because it was our belief that if we went to trial, we would prevail.
But your report differs, if you look at Special Counsel Herr's report and Special Counsel Mueller's report. The language that you use and the way you describe the things that you believe President Trump committed, is different. Her was careful to use words like jurors could find or might, at most, would likely conclude, whereas the language you use is pretty definitive.
Her report states his assessment of the evidence. Mine does as well, and as I said, I feel and feel to this day that we had a very strong case, and so I communicated that.